Afternoon and welcome. Good afternoon. Welcome to our presentation on employment law and reasonable accommodation. We thank you for being with us today. The Disability Law Center is the protection and advocacy system for Massachusetts. We advocate on behalf of people with disabilities on civil rights issues such as employment discrimination. We also have a federal mandate to monitor and investigate abuse and neglect of people with disabilities. My name is Tom Murphy. I'm a supervising attorney here at DLC, and I'll be the host today. Our presenters are Riz Huda and Matt Steele. They are both staff attorneys at DLC who have experience representing individuals with disabilities in employment and reasonable accommodation matters. Next slide, please, Amanda. Today's presentation is funded by the Social Security Administration, under which DLC receives a grant. Although Social Security reviewed this document for accuracy, it does not constitute an official Social Security communication. This communication is printed, published, or produced and disseminated at U.S. taxpayer expense. Next slide, please, Amanda. So our training objectives for today are to provide an overview of disability rights in employment with a focus on federal law, to discuss common issues facing people with disabilities with respect to job applications and within the workplace, to learn about requesting reasonable accommodations in the workplace, and to help you to determine when to seek additional help for yourself or for an individual with whom you're working. We're going to leave time at the end for questions. So please hold your questions until the end of the presentation. You'll see at the bottom of your screen, there is a Q&A function. If you do not, if there's a misunderstanding with respect to something that we've covered, or you need a fuller explanation of something that we've already covered, please feel free to use that. I will do my best during the presentation to address those as they pop up. But again, we do plan to leave time at the end of the presentation for questions, so please try to hold your questions until the end. We've known that in past presentations, many of the questions that come up during the training itself are in regards to issues that we will be covering later on during the presentation. We also have a few slides where we will be introducing poll questions for the audience to provide answers, to give a sense of a little bit more of interaction during the presentation. So we will let you know when those polls are ready to go. For the most part, the answers will be either yes or no, or additional information is required. So with that being said, we can go to the next slide, and I will turn things over to Riz.
Thank you, Tom. My name is Riz Huda. I'm an attorney at the Disability Law Center. And I'll start off, when most people get a job, they start the process by a series of interviews, and then they come in for orientation, and they probably might sign some document during that orientation. But most people don't sign is what's called an employment contract. And for the majority of employees, they're called, the term is called an at-will employment. And basically that means that employers can terminate the employee without cause. And the exception to that would be if you had an employment contract, if you're in a union, you have a CBA, or even public policy like whistleblower. So when we say that an employer can terminate an employee without cause, that doesn't mean that an employer can illegally terminate an employee. For example, an employer cannot terminate an employee just because they're in a protected class. For example, they have a disability, so they terminate you. That is illegal, even though you're an employee at will. Next slide, please. So let's talk about some workplace protections for people with disability. When we The workplace protections start at the very beginning of the job process. So this means the job application procedures, and this would be any kind of portal or whatever technology the employer requires the candidate to apply. If you need some kind of accommodations or you need to do it differently, you're protected under the law to do that and to request that. Most people, when they think about workplace protections, are talking about the hiring firing process, but there's also workplace protections for benefits and compensation, advancement, training. An employer cannot deny employees with a disability opportunities for training or increased compensation just because they have a disability. So really, any terms, conditions, or privileges of that employment is protected. Next slide, please. Continuing our discussion on workplace protection, we're going to talk about this term a lot. The state and federal disability laws requires employers to provide what's called reasonable accommodation. And what that is a change or an adjustment to a job or work environment that allows a person to participate in the job application process and also to perform any of the essential functions of the job. So just to break that down, when we talk about essential functions of the job, these are the key tasks to get the job done. A lot of employers actually in the job description have identified these essential functions. So what we were talking about just in the previous slide is that if you need some kind of accommodations during the job application process, you can ask for it. And again, a reasonable accommodation is a variance to the normal corporate policy based on your disability. Next slide, please. Next slide. Thank you, Amanda. Let's talk about specific laws that apply. The Americans with Disabilities Act was enacted in 1991 and applies to employers with 15 or more employees. In Massachusetts and the Commonwealth, General Laws 151B, Section 4 covers employers with 6 or more employees. When we talk about the ADA, we're talking about Title I specifically. There's also the Rehab Act. This is Section 503 of the Rehabilitation Act of 1973, and this applies to federal employees or contractors of federal employees. The protections are more or less similar between federal and state law, with the difference being the number of employees that it covers. So the ADA would cover employers that are a bit larger than state law. Next slide, please. So an employee is protected under the ADA if they have a physical or mental impairment that causes a substantial limitation of one or more major life activities. So that there's a lot in there, and I want to unpack that a little bit. First of all, what's a major life activity? This is breathing, eating, talking. Now, there is other words such as substantial limitations and major. What's the major, what's the minor, what's substantial, and what's not. These are basically been interpreted by courts as being very narrow, and that led to what's called the ADA amendment. But before we talk about that, um, you know, you should know that if you have a record of an impairment, whether it's a learning disability or you're a cancer survivor, you're protected under the ADA. And you're also protected under the ADA if you're regarded as having an impairment, even though you don't have that impairment. So it could be a mistaken belief from your employer or from your that you have a particular impairment, and they can be discriminating against you when you actually don't. So you'll be protected under the ADA under those circumstances. Next slide, please. So as I talked about, the ADA amendments were enacted in 2008, and basically they were enacted to broaden the scope for the protection of individuals with disability. The actual definition did not change, but by narrowing the scope of protections intended afforded by the ADA, it basically eliminated the protection for individuals with whom Congress intended to protect. So Congress did enact the amendments in 2008. This includes all major life activities. So, for example, when we talk about that, we're talking about bodily functions such as your immune system, cell, digestive system. If you had a heart operation, for example, you would be covered because that would be the circulatory system. There's also the neurology system, and courts were told not to consider mitigating measures. Impairments that are episodic or remission are also covered when they're substantially limiting when those impairments are active. So, for example, if you have cancer and you're in remission, you're still covered under the ADA. Next slide, please. I think Matt is I'm going to hand it off to Matt here.
Thanks, Riz. My name is Matt Steele. I'm a staff attorney at the Disability Law Center. I've been doing employment cases on and off for about the past 7 years, and I really enjoy this part of my work because no two cases are alike, and we'll get a lot of examples as we go throughout the presentation, and everyone's situation. Everyone's job is going to be a little bit different, everyone's disability is going to be a little bit different, and the accommodations that they need are also going to be a little bit different. So it's an interesting area, very intellectually stimulating. And just want to thank everyone for joining us today, of course. So Riz has covered some of the foundational laws that govern employment law and reasonable accommodation. We're starting to define some of our terms. I'm going to the next couple of slides are stepping back a little bit to have some important points to keep in mind as we apply some of the knowledge that we're learning to specific scenarios that we're going to be looking at today. Over the next few minutes, I'm going to talk about some of these important points, introduce the subject of disclosure, when to disclose a disability, when not to, and how to go about doing it. And then I'm going to talk about the job application process and how reasonable accommodation law impacts that process. After that, it'll go back to Riz. But hang on to your seats. We are going to have some interactive questions coming up in about probably less than 5 minutes. So we'll be able to test our knowledge momentarily. So some of the important points to keep in mind, there's really two on this slide. The first one is something that Riz has already touched on a bit. It's that reasonable accommodation is meant for the employee to help them perform the essential functions of their job. The slide says, with or without a reasonable accommodation, for today's purposes, we're really talking about how people with a disability get the accommodation that they need to perform the essential functions of their job, which thereby makes them a qualified employee. So when you're looking at or thinking about what to request for reasonable accommodation or helping someone apply for reasonable accommodation, you have to keep in mind that there are some frameworks for this. And most important one is that the employer still kind of gets to control the terms of the position. The job has to be performed correctly and within the employer's expectations. You have to do so following whatever safety protocols the employer has in place. And you have to do so in line with whatever policies and procedures and overarching laws govern that particular position. That's fairly abstract. So just to think about some real life examples, employers aren't required to lower production standards, for instance, whether you're looking at something quantitative like a delivery driver, maybe you have to do 100 packages per shift, something like that. You wouldn't be able to request a reasonable accommodation to do 75 over the course of a shift. Your reasonable accommodation request would really have to be geared toward finding a way for you to meet that baseline production standard of 100. Relatedly, if you're looking at a qualitative standard, so maybe you're a customer service representative who answers phone calls from customers all day long, in addition to having some kind of quantitative number that you have to hit, number of phone calls, you're also going to have to probably be polite to the customers and not swear at them and things like that. So you wouldn't be able to request as a reasonable accommodation that an employer waive its qualitative requirements for a position in order to be qualified. The second really important point on this slide, and again, what makes this really interesting area of law is they're generally reasonable accommodation requests almost always have to be decided on an individualized case-by-case basis. And that works both ways. Employees aren't necessarily just allowed to say, I need this reasonable accommodation, you got to give it to me. And employers aren't allowed to say, we don't give that kind of reasonable accommodation. Every situation is different. Everyone's needs are going to be a little bit different. And each of these has to be assessed by case by case. Typically, if your company is big enough, it's going to be handled by human resources department. If it's a smaller place of business, it might be a supervisor who's handling that. We'll kind of break down some of the nuances of that coming up. So at this point, I think we can move to the next slide. Just continuing our discussion of important points to keep in mind as we go throughout the presentation. Riz mentioned earlier that the ADA has been amended once, just to clarify that the focus really shouldn't be on, does this person who's asking for the reasonable accommodation, do they really have a disability, or is such and such medical condition a disability? It's focusing on providing accommodations to help people meet that definition of qualified to perform their job, and figuring out what is reasonable in the individual circumstances, rather than focusing on, is this a disability or not? That doesn't mean you don't have to provide verification that you have a disability. That often comes up. We'll talk about that later on. But just know that the focus is much more on, what are the job functions? We already said, when we're trying to figure that out, we look to the job description, but we also look to what people in that position are actually doing on a day-to-day basis to determine what are the essential functions. We look at the job performance, and we also want to think about the timing of the RA request. We'll kind of touch on this in some later examples, but it's almost always better to request the reasonable accommodation proactively before you get into any kind of disciplinary situation with your employer. And, sometimes get to momentarily, you're going to need a reasonable accommodation just to apply for a position, depending on the nature of the disability. We'll touch a little bit more later on the interactive process. That's this sort of back and forth between the person requesting the accommodation and the employer, whether it's HR, supervisor, whatever, handling the request, how to go about navigating that process. We'll give you some more pointers later on, but just know for now that employers are required to engage in an interactive process. That's, again, going back to this idea of an individualized case-by-case assessment of every request for reasonable accommodation that an employee puts in. Last point on this slide is really just emphasizing the idea that don't wait until you get in trouble at work to then say, hey, I have a disability, I need accommodations. It's almost always, again, better to get out ahead of it and have a reasonable accommodation in place that will allow you to perform your job functions in a satisfactory manner, so that you don't have anything on your file from whatever problems began. So I think that's enough on this slide. We can jump to the next one. The next two slides, the next few minutes, we'll just talk a little bit about the subject of disclosure, when and why you may want to disclose that you are a person with a disability, or that you're working with a person with a disability, and how to go about putting in a request for reasonable accommodation. The timing of this stuff can be really important, especially if you're looking at a job application. So it's important to remind everyone that job applicants are never obligated to mention that they have a disability at all. In some cases, it will be obvious. In other cases, such as a psychological illness, mental illness, it wouldn't be obvious, and you would never have to disclose that. The only time you have to do that is if you're asking for a reasonable accommodation. Employers, for their part, they are allowed to ask job applicants, are you able to perform the essential functions of the job with or without a reasonable accommodation? If the answer to that question is yes, the employer really then has to move on. They're not going to be permitted to say, well, you look like you might have this disability. Tell me more about that. If you answer no to this question, then you you might not be qualified for the job. So it's a little bit of a dance, and if the answer to that question is no, then you may have to try to figure out how you're going to craft a reasonable accommodation that would make you qualified for that position. So that, again, the timing of your disclosure is going to depend on the accommodation you may need. If you're, for instance, if you're deaf and you need an interpreter to apply for a job just to sit through the interview, then you're going to have to disclose it at the time of the job application. We had that very case last year. There's an individual who was applying for a security position. She was invited to the interview without the employer was aware that she was an individual who was deaf, but was not going to provide an interpreter at the interview. She repeatedly urged them to try to get an interpreter for her, an American Sign Language interpreter. The employer didn't, and so she had to go through the interview, basically lip reading and writing notes to back and forth to the supervisor. So it was not at all an ideal situation, and Disability Law Center was able to jump in and get the job applicant a proper interview with an ASL interpreter, and a promise from the company that that wasn't going to happen again. There's been clear guidance around since the early 1990s that ASL interpreter is almost always going to be required for someone who's deaf who's seeking a job. So that's kind of an easy example. I think we can move to the next slide now, which addresses the question of why disclose at all. And that's a harder one. It's clear that there's a big societal stigma and discrimination against people with disabilities. I get emails from the Equal Employment Opportunity Commission summarizing cases that they have and charges that they file on a monthly basis. There's almost always a case where an employer learns about an employee who is either has a disability or has become disabled, and that employer immediately just terminates that employee, and then the case unfolds from there. So there's clearly risk to doing so. These cases come from all over the country, and people who live in the real world have to make real decisions about when and how they're going to disclose. So as a reminder, you don't have to disclose unless you're asking for a reasonable accommodation, but be careful if you're going to go that route, because the ADA, state employment law, it only kicks in when we're talking about known disabilities, and by that we mean that the employer has some knowledge that you or the person that you're working with is a person with a disability. So just to go back to the basics here, you've got to determine, do you really need to disclose? If the answer is that you do need the RA to perform your job, then yes, you do. When to disclose is a harder question. It's typically going to be better to wait until you have started your job to seek a reasonable accommodation, unless you really feel like from day one you're going to need certain equipment to perform your job, or certain break times, things like that are non-negotiable for you based on your disability. You might have to disclose pre-hire. And then how to disclose, again, everyone lives in the real world, so it might be better for you to write a letter to Human Resources. It might be better to have an informal conversation with your supervisor if that's a person that you trust. But I think we'll remind you a little bit later, whatever you do, you generally want to get some kind of written documentation of your request and try to get your employer to give some kind of written response to that request. I think we can jump to the next slide, which gets us to the job application process. So we're getting further into the nitty-gritty here of different types of job accommodations that employers can provide during the job application process. And we've got a couple slides on that, and then we'll have an opportunity to test our understanding of this information by answering some poll questions in just a little bit. So hang on for that. But as Riz kind of already mentioned, employers have to provide reasonable accommodations to assist applicants who are being considered for a job. They have to provide written materials in an accessible format. That might mean providing large print to someone who has low vision. ASL interpreter to someone who is deaf. They might have to move the interview location to somewhere that's accessible. If, for example, you're interviewing someone with a mobility impairment, that interview might have to take place in a different place than it normally does so that it's accessible to that person. Modifications to equipment or devices that would be used um, in a interview. That's a little bit less common. And then adjustments to the application, policies, procedures, tests, things like that. We're going to see some specific examples of that later on, but just for now, think of that as a company that only has an online portal for people to apply to their jobs on, or a grocery store like Whole Foods that wants you to take a personality test as part of your application. There might be some people who can't do that online on a computer. In those cases, an employer would have to be able to provide some other way of doing it, maybe a paper on pen personality test rather than an online one through a portal, if the employee had a disability that prevented them from accessing the portal. I think we can move to the next slide. So just one more slide on reasonable accommodations during the job application process. We've got two specific examples. I'll take a minute to read them out and give everyone a chance to think about these ones. So the first example is Sarah. She is blind and applies for a job which requires the use of a computer. With assistive technology, Sarah can perform such job functions. If the employer requires applicants to demonstrate their computer skills, it must provide Sarah with the technology. So the idea here is giving a level playing field for everyone. If Sarah isn't provided with a reasonable accommodation in that instance, she would not be getting an equal opportunity to apply for that position. So it's pretty clear that the company would have to provide assistive technology for Sarah. Second example is a large employer requires applicants to apply electronically. Jim has an intellectual disability, which makes this process difficult for him. The company should allow Jim to apply using a method which he is more comfortable with. That's the example that I just gave a few moments ago. It's someone with an intellectual or developmental disability who doesn't necessarily have the computer literacy to go through an online job application process. The best practice really for employers these days is to identify in the job description or the posting the person to contact for reasonable accommodation. See that more and more now. It'll say it toward the bottom, if you're a person with a disability who requires a reasonable accommodation, then contact so-and-so at this phone number or email address to request an application. That's where this comes from. It's rooted in the Americans with Disabilities Act. Next slide, please. Okay, are we polling on this one? Or
Yes, we are, Matt.
okay, great. So we're going to do our first poll, which is very exciting. We're going to ask you some questions to see how well we've been taking in the information about whether a question is permissible or not for an employer to ask during the job interview setting. So if we can go ahead and roll out the first question.
Sure. So you will see on your screen a poll pop up, and your choices will be yes, no, or need more information. And the question simply is this an okay question to ask during an interview? So the first one is, do you have certification as a child care provider? The poll is up. Please indicate what you think is the correct answer. We'll leave it open for just a few seconds. These are pretty straightforward. So pretty overwhelmingly, most people think that this is an okay question, Matt.
That's great. I would say you're certainly correct that this is okay for an employer to ask. It's a neutral, disability neutral question. Let's assume that you're running a daycare agency and you're hiring for a staff position. As an employer, you really need to know who has a certification for that job or who doesn't. I saw a couple of folks might have put needs more information. And yeah, if you weren't applying for a childcare related position and the employer was asking that, there could be some factual scenarios where it might be impermissible, but it's a little bit of a stretch.
Thanks, Matt. So the next question that might come up during an interview, can you safely climb a ladder? Is this okay or not? So a little bit more disparity on this one, Matt. We've got about 70 or so percent think this is okay. About 30% think we might need some more information here.
I think I think everyone's a little bit right on this one. If you are applying to work as a maintenance worker, employer absolutely would be able to ask you if you can safely climb a ladder. That's very likely going to be an essential function of your job. You're going to have to change light bulbs, clean gutters, things like that. That goes back to our kind of baseline requirements for being qualified. Um, if you were applying for a different type of position and the employer might be using this question to flag people who have a disability or mobility disability, vertigo, whatever it might be, then in that case, it might be an impermissible question.
Thank you. So the next question, do you have a driver's license? If this comes up during an interview, is this okay? This is about 50-50, which is interesting. So about 50% think it's okay. About 50% think we need more information here.
I would say either answer is probably correct. If the job that you're applying to is for the delivery driver job, absolutely an employer can ask this question. If you're working in an office as a secretary and you're not going to need to drive to perform any functions, the essential functions of your job, then this question, you kind of might need to know a little bit more information about what job you're applying for in order to determine whether this question is okay or not.
Okay, great. The audience is doing really well. Last question for this slide. Were you ever fired from a job because of attendance problems? Do you folks think that that's something that an employer or potential employer can ask? We're getting quite a few more not okays on this one, Matt. So about 2/3 think this is not okay. About a fifth think we need more information, and about a fifth think this is okay. So should have a robust discussion on this one.
That's an interesting split. We actually think there's a pretty clear answer to this question. We're not trying to trick you. If you were it is okay for an employer to ask if you were ever fired from a job because of attendance problems, because that would apply whether you're not showing up because you were blowing off work or because you were sick with cancer. It's a disability neutral question, at least on its face. I am curious why people would want to know more information. But basically, it's a question about whether you were ever fired because you weren't showing up for work. It's not a question of did you not show up to work because you were too sick, which would be impermissible, because that would go to getting at someone's disability.
Thanks, Matt.
I think we can jump to the next slide. So talking about still sort of in the realm of job applications or early on in the employment phase, and there's sort of a separate category for people who have observable disabilities. And what we mean by that is if you're blind or low vision and you're using a white cane to get around, if you have a mobility impairment, you're using crutches or in a wheelchair to ambulate, then you have what's called an observable disability. It opens the door up a tiny bit for the employer to ask a little bit more about how you would perform job functions. Because we said earlier that the employer is only really supposed to ask you at the job application phase if you can perform an essential function of your job with or without a reasonable accommodation. Little bit of a caveat for people with observable disabilities. Employers still can't ask medical questions just because you have a disability. But if you're applying for a job where it might be a little bit questionable about how you would perform certain essential job functions, then the employer can really just ask you questions about how to describe, please, how you would perform a certain job function. And that could and probably often does lead to a discussion of what reasonable accommodations might be required for the employee in that scenario to just to be able to be successful at his or her job. Next slide, please. So we're past the application phase. We have a sort of another nuanced area for conditional job offers for particularly for jobs that involve public safety, sometimes transportation, where an employer can require a medical examination after giving you a conditional job offer. So sorry, think you've got the job, but you still have to take this medical exam. Go to medical center ABC, and you're going to see this doctor who's going to give you a physical. And then if you pass the physical, you're going to get the job. Employers can't do this selectively. They have to do it across the board. The top sort of 3 or 4 categories that come up often in this regard are police and public safety officers, firefighters, certain medical professionals, and then airline pilots, for example, often have to do extensive medical exams at the time they're hired, and then every 6 months to a year, depending on what their role is as a pilot, they're going in for pretty regular physical exams due to the significant public safety risk. So you can require the medical exam if you're doing it for everyone. The exams are supposed to be designed to measure your ability to do the job that you're assigned, whether it's going upstairs, running a certain distance, things like that. And the employer still has to be willing to consider accommodations that would permit you to perform the job functions if the medical exam showed that you might be weak in a certain area. And of course, an employer can't withdraw a job offer just because the exam happened to show that you have a disability. The medical exam would really have to show that you were unable to perform the job with or without a reasonable accommodation. With a reasonable accommodation, rather. Next slide, please. And I'm going to kick it over to Riz so we can do some more polling questions and get deeper into the presentation.
Thank you, Matt. That was fun. So we're going to keep going with our polling questions. So can we go to the next slide, please? So this is a test of your understanding of who is a protected individual. The first one is example that we have is John has been hospitalized twice in the past year for heart condition. He has no symptoms at the present time. The question is John an individual who's protected under the ADA?
Okay, and I've launched the poll, and again, choices are yes, no, or need more information. The question, does John have an ADA disability? We have a split in the circuits here, Riz. It looks like about half think the answer is yes, and the other half either no or we need some more information.
Well, I would say thank you, Congress, for the ADA amendments, because John is protected under the ADA because he has a record of his disability, which is his heart condition. So even though there's no symptoms at the present time, he's still protected under the ADA. The next one is Carol has been feeling sad because she recently broke up with her boyfriend. For the past week, she hasn't been sleeping well. Is Carol an individual that's protected by the ADA?
Poll question is up. Pretty overwhelmingly, folks think that the answer is no. There are a few that think that we might need some more information here.
Yeah. I on the face of it, it looks like she's not protected by the ADA. If I was speaking with Carol, I would ask her to try to get some more information on why she's not sleeping well and if that's at all related to her disability or not. But feeling sad because of a breakup does not rise to a disability. That was good. So the next The next example is that Dan has epilepsy, which is controllable with medication. For the past week, he's been out sick with the flu. His employer fires him. Is Dan protected under the ADA?
So the answers are coming in, Riz, mostly in the yes column, that Dan is a person with a disability protected under the ADA. About 2/3 feel that way.
Yeah,
Some folks feel
this
that we
is a
need some
really
more.
good example. I like this example for a couple of reasons. The answer is yes, he is protected under the ADA because he has epilepsy. So therefore, he is protected under the ADA. Now, the fact pattern tells you that he's been terminated and he was out sick with the flu. So it implies that we don't know this, so we need to get more information, but it implies that the employer terminated him because he was sick with the flu. So we would have to look at the employer's sick policy. We would have to get more information on how his peers are treated that have also been sick. Have they also been terminated under those days that they take the same number of sick days? Those are the kind of information. That's the kind of information we need. Because there's always a chance that his employer fires him as a pretext because he has epilepsy, and if that is the case, then that definitely is not legal, and he is protected under the ADA. Next slide, please. We're going to continue to test your understanding with some more examples here. And the question is, can employers do the following? An employer posts a job opening which requires an ability to drive of applicant. Is that okay or not okay?
So can an employer have that requirement in their job posting? Ability to drive. Most folks think the answer is yes, Riz.
Yeah, and again, we touched on this a little earlier, Matt did. It depends on the type of position. Obviously, if it's a bus driver position or Amazon driver position, then yes, because the ability to drive would be an essential function of the job. If the ability to drive is not an essential function of the job, say it's a desk job, then again, and that would not be okay in that case. So it really depends on the position and what the essential function of that position is. The next example is during the interview, Anna is asked whether she can perform an physical agility test. Is that something that the employer can post on the?
So whether Anna can safely perform a physical agility test. Can she be asked that question during an interview? Okay. More than half think that we need some more information on this one,
Yeah,
Riz. The
yeah,
other half is split.
Well, I would agree with the more information because there is an example where an employer can ask that legally. For example, if she was a firefighter and a physical agility test, um, if an essential function of the job is means that you have to be physically have to climb X amount of stairs and carry some heavy equipment around into a burning building. Certainly, this test would be part of the essential function of the job, and that would be okay. However, if the job is like a desk job where it's not part of the essential function of the job, then no, this question is not okay. The next example is Richard, who has diabetes, indicates during his interview that he will need periodic breaks to take medication. The employer asks how many breaks he would need and for how long. Interesting, huh? So is this a question that the employer can legally ask?
The poll is up, and let's see. We've got more than half of the folks in the audience think that this is okay, about 70% or so. The rest are split between no and need more information.
Yes, and the employer can ask this, and the reason for that is because what Richard did was he opened the door for the employer by disclosing his disability during the interview process. So once you open that door for the employer, the employer can ask questions related to the reasonable accommodation, which the question that they ask seems to be, it's related to his reasonable accommodation. But what the employer cannot do is go on a fishing expedition on your medical history. They can't get more information on your general medical information.
So Riz, it seems to me that a lot of the answers to these questions come down to what the essential functions of the job are. Is that correct?
Yeah, that is correct. Yeah.
Thanks.
Next slide, please. Then we want to talk a little bit about the steps in the law after an employee starts employment. So anytime after employment, an employee can request reasonable accommodations. An employer must provide these reasonable accommodations. And again, a reasonable accommodation is a change or adjustment to a job or workplace that allows the person with disability to perform those essential functions of the job. There needs to be a connection between your disability and your reasonable accommodation request. So whatever you're requesting needs to be tied back to your disability. That's really important. Next slide, please. I want to discuss some examples of reasonable accommodations, and Matt will talk about all these examples a little bit more in detail later on. But this is from a general overview perspective, some examples that employees can request. And the first one is a modified work schedule. This could be a part-time schedule. Again, this assumes that employee has a disability, they can't work full-time, and they may have to take some hours off to do something that's related to the disability. An employee can also ask for job restructuring, retraining, job coach. We see a lot of cases where employees have job coaches and they've been very useful, helpful, I should say, to the employees. An employee can also ask to be reassigned to non-essential functions. I'm sorry. So again, we talked a lot about the essential functions of the job, which an employee must do with or without reasonable accommodation. But regarding the non-essential function of the job, this is functions that you do but not needed on an everyday basis to perform the task. You can ask as a reasonable accommodation to reassign those. An employee can also ask for a leave of absence. And overall, to make the workplace more accessible, what that means to one person with disability will look totally different with somebody else with another disability. So it really depends on the employee with a specific disability and also on what the workplace, the layout is. And of course, every workplace will be different. An employee can also ask for reasonable accommodation to provide interpreters or readers. So this include ASL as well, and providing modified equipment or devices. We talked a little bit about this even, you can ask for this even during the hiring process. I'm sorry, during the job application process, where if you need assistive technology to apply for the job, if you've been offered a job and you start the job, you can request assistive technology to perform those essential functions. And as a last resort, an employee can request to assign a job reassignment. And again, that would be a last resort as a reasonable accommodation. Next slide, please. Now I want to discuss circumstances where reasonable accommodation is denied. So reasonable accommodation must be provided unless there's an undue hardship or a health or a safety risk to the employees or others. And we want to talk about these terms a little bit because these terms are what's called affirmative defenses. A health and safety risk, we see this in hospital settings a lot. And again, the risk has to be real. It needs to be an actual risk that's that you're putting on, that the employer will be taking on by implementing those reasonable accommodations. And the risk can't be speculative. So there really needs to be proof of safety risk if the employer is going to respond or take this response. An undue hardship is really defined as requiring significant difficulty or significant expense. Now, this is a relative term because what's an undue hardship for a small employer is going to be different than a large employer. And employers must provide an effective accommodation, not necessarily the accommodation that the employee has requested. So you might be asking what's effective. Well, an effective accommodation would be, in this case, would be an alternative accommodation. So it's not the one that the employee requested, that allows the employee to perform the essential functions of the job. So essentially, the employee may ask for A, and the employer may come back with B and or C, and as long as the accommodations that the employer is offering allows the employee to perform those essential functions of the job and addresses the needs of the employee's disability, then that would be an effective accommodation. Again, when we talk about undue hardship, and they're really fact specific to the employer and the nature of the job. So there's really no like template or anything like that. We really have to. All these situations are unique, and all of them are fact specific to the disability and to the employer. Next slide, please. So I want to discuss the logistics on how employees can make a reasonable accommodation request, what the process is. We recommend that employees make their reasonable accommodation request to the supervisor and to human resources, and to make that request in writing. Now, why do we say writing? Because we want to create a record of what's going on. Usually when you have these kind of like sidebar conversations, it leaves a lot of room for interpretation. And but putting everything in writing will clarify it. So it's okay to have that conversation with your supervisor or someone from HR, but you should follow up with an email. An email is sufficient. It just puts it in writing. What your understanding of that conversation is. And basically when you make your request for accommodations and you put it in writing, you should tell your employer the nature of your disability, the reason of the request, and what exactly you're requesting, the requested accommodation. So when you make that request, you should tie in your disability to your accommodation. What's the connection? So you should put that in your reasonable accommodation request. And most employers will ask for what's called medical support, which is a doctor's note explaining the disability. And this should be updated. So the doctor's note should explain the employee's disability and the accommodation requested, how this accommodation would help the employee. Next slide, please. Continuing our discussion on the reasonable accommodation process, the employer may ask for documentation describing the impairment and how it relates to the reasonable accommodation if the impairment is not readily apparent. What Matt was talking about, observable disability. They can ask for more information related to your disability for sure. But what they cannot ask for is basically general information about the employee. They cannot ask for medical conditions or impairment unrelated to the reasonable accommodation request. So basically, I alluded to this earlier, they can't go on a fishing expedition on your general medical condition. It's actually not legal for them to ask for medical information that is outside the scope of your disability and the reasonable accommodation requested. Next slide, please. I talked about this a little bit in a couple of slides earlier. There's this back and forth that goes between the employees and the employer on when they ask for reasonable accommodations, and that's called an interactive process. And it's basically what it sounds like. It's a back and forth between the employee and the employer, where the employee will ask for a specific accommodation. The employer will come back and say, we can't do that, but we can do this other thing. And then the employee will say, well, that doesn't really work for me because I can't perform the essential function of the job. It doesn't really address my disability. And then they may pick another alternative accommodation. And that itself is called the interactive process. And that's a legal term, and it's triggered right away when the employee requests the reasonable accommodation. It actually triggers the interactive process. There's a website that's really, really useful. It has several hundred available resources in determining what an effective accommodation is. And I really recommend employees with disabilities to look at this website before they even ask for the accommodation, because there's so much in this website, and that you can contact them, explain to them what your disability is, what your task what you may be having difficulty with, and they can offer you basically accommodation. So we always recommend maintaining a paper trail. We always recommend having a record, and it's really important because what happens is time goes on, and people tend to recall things differently, and people interpret conversations differently as well. So if you have a paper trail, again, emails is sufficient, where you can go back and basically there'll be a record of what happened, what you requested for. If there was an alternative accommodation by the employer, that should be recorded in an email. And then when the employee requests another accommodation or does not explains to the employer during the interactive process why this alternative accommodation is not going to basically help them perform the essential functions of the job, that should be all part of the email. That should be all part of a record. So the employer can't say, well, I already offered them something and they keep saying no. You need to explain to them why that alternative accommodation is not good enough. It's not related to your disability. And then that puts the burden back on the employer to really uh, figure out what alternative resources, what alternative accommodations they can offer. Now, the last bullet point basically makes the point that this isn't a one-time thing. Once you have a reasonable accommodation and that's agreed upon, you can always follow up and modify that reasonable accommodation. Next slide, please. So continuing our discussion on the interactive process, the main thing that I really want the participants to understand from this slide is that it's really important for employees to participate in the interactive process. It's employees that haven't engaged in the interactive process, when they've been to court a couple of years later, courts have ruled against them because they were so inflexible, and they kept saying they wanted the specific reasonable accommodation, and they weren't open to any of the what we call the interactive process. They weren't open to any alternative accommodation, and because of that, they lose their court case. So from the very beginning, it's really important that employees maintain flexibility and really record the fact, put it in writing that they are flexible. So again, the interactive process should render an accommodation of what is called an effective accommodation. Between that back and forth and back and forth, at the end of the day, you should have what's called an effective accommodation, which is an accommodation that allows the employee to perform the essential functions of the job. It may not be the original accommodation the employee requested, and that's okay. Next slide, please.
Now it's back to me. I just wanted to say congratulations, everyone. You've now learned basically all the fundamental concepts of reasonable accommodation and employment, from job application to having the job in place. The remainder of the time together today, we're going to look at some more specific examples, ones we've already alluded to. We're going to practice our understanding with some more poll questions, and we're going to conclude with some tips and resources for you. And we're still going to allow at least 10 minutes or so for questions at the end, so we can get into some more specifics on that. The first example, the first large category of examples we wanted to go over was job restructuring. I'm going to read the example that we have here, and then we'll take a poll question to see how we feel about it. Bill takes medication which limits his ability to drive in the early morning. He applies for a job as a school bus driver and during the interview is asked whether he's available to drive mornings between 7 and 9 and afternoons between 3 and 5. I'll give us a second to pull up the first poll question.
So the poll question is up, and the first question is this a permissible interview question? And again, now that we're getting a little bit more in-depth into different types of reasonable accommodations, where we're focusing on what the essential functions of the job are. So let's think about that a little bit. And also, as Riz just alluded to, are there accommodations which might be effective? Effective meaning that there is an accommodation, not necessarily the one that the person originally asked for, but an accommodation that does allow the person to perform those essential functions of the job. So, Bill has asked this question about his ability to drive in the morning and in the afternoon during his interview. Is that okay? And Matt, 93% of our audience thinks that that is okay.
Yeah, I certainly agree with that. The job is for a bus driver both in the morning and the afternoon, as far as we can tell from this example. So definitely fair game for the employer to ask if he can do both shifts.
Thanks, Matt. So the next question, is Bill a qualified individual? I'll launch the poll question. Now we're thinking back to our definition of qualified, meaning that they can perform the essential functions of the job with or without a reasonable accommodation. We've got a little bit more disparity in our answers here. About half of the folks in the audience think that Bill is not qualified for this job, and about half think that we need more information. What do you think, Matt?
Depends on what day you ask me, Tom, but today I'm going to say that he's not qualified for the position based on the amount of information that we have, which is an employer who needs someone to cover both the morning and the afternoon shift. But we've got one more question to kind of tease this out a little bit better.
Yeah, so I think your answer to that question, and again, getting back to the qualified, either with or without a reasonable accommodation, begs the question, is there an accommodation that this employer can provide? So this is yes or no, or need more information. Can the employer reasonably accommodate Bill regarding his inability to drive in the morning? And about half of our audience, maybe a little bit more than half, think the answer is no. About a third do think that there is an accommodation potentially, and about 20% think that we need more information.
I'm going to go with the 20% that says that we need more information to determine whether we can figure out a reasonable accommodation for Bill. Remember what Riz said earlier. What I said earlier was that all reasonable accommodations have to be decided on a case-by-case basis, very individualized analysis. And what Riz said a little bit later was reasonableness is often determined by the size of the employer and the resources available to the employer. So if we're in New York City and they've got 500 bus drivers in the morning and 500 in the afternoon, it might be possible for that size employer with that level of resources to simply offer Bill the afternoon position. It also might be possible for Bill to take his medication at a different time, and that would permit him to drive the bus safely for both shifts. Those aren't the facts that are presented to us, but it's something that's worth thinking about as we look at any kind of individualized assessment.
So there might be some undue hardship issues involved there, right, Matt? If Bill's applying for a job in a very small town where, he might be the only bus driver for the one small school that they have in the town, then accommodating him in some way may amount to an undue hardship.
Yeah, that's the flip side. For sure, an employer is not going to be required to hire 2 bus drivers to fill one bus driver position. That would be a clear example of an undue hardship for an employer.
Thanks.
All right, I think we can jump to the next slide. This one is an example. Just provides a couple of different categories of examples. No particular slide questions with these ones. Job coach is something that we see from time to time as a reasonable accommodation for a new employee, more often for a new employee. Job coach is someone who is either provided by The company, or more often, I think, provided by a third-party nonprofit who provides vocational rehabilitation services for people with disabilities looking for jobs or who found jobs. Case I had maybe 2 years ago now was with a large supermarket chain in Massachusetts, and uh, my client was an individual who had an intellectual disability. He worked as both a bagger and a shelf stocker, and the employer in that instance was um, not providing the job coach. It was a third party. But it's also worth mentioning the individual had worked for many, many years in that position. He always had a job coach, and it looked like he pretty much was always going to need a job coach due to the nature of his disabilities. The employer in that case was totally fine with the employee having a job coach in perpetuity. All of the laws that we've been talking about today are really sort of setting the baseline and the threshold for what employers are, the minimum requirements that employers are legally obligated to provide for people with disabilities. But a lot of employers can and do go beyond those sort of minimum requirements. So it would be a little unusual to have a job coach in perpetuity, but this particular employer was totally fine with it, and that's great. Um, the other large category of reasonable accommodations tend to be regarding equipment and devices that people need to perform their jobs. There's almost an infinite variety of technology that can help people do their jobs better depending on the nature of their disability. Speech to text, screen readers, things like that. Even something as simple as a stool. I had a case when I worked in New York of a woman who worked at one of those makeup counters at a Macy's or one of those big department stores, and she had some orthopedic issues and needed to sit down for just a few minutes every hour. The employer would not let her have a stool. They did not like the look of their salespeople sitting down while they're on the job. So that was a little bit of a fight to get the employer to come around on that. So again, there's lots of equipment that is going to be required. The cost of having a stool is minimal, and employers aren't. This goes back to employers aren't able to say as a matter of blanket policy, we would never provide a stool to one of our employees. Let's jump to the next slide. We're back into the land of polling and questioning back to the audience. This one is regarding a modified work schedule. We've touched on this topic already. I'll read the example and then we'll ask a couple poll questions. Natalie is an administrative assistant and sees a therapist for major depressive disorder. The therapist can only see her in the morning, and she is occasionally late for work. In order to complete her work on some days, she has to stay late.
So our first poll question goes back to topic that we touched on much earlier in the presentation. Does Natalie have a disability? And all of our audience is saying yes, Matt.
Yeah, that's correct. She has a mental impairment that substantially limits a major life activity. We didn't say this earlier, but there's no one list of all disabilities that would be qualified under the ADA, but major depressive disorder, I think 9 times out of 10 is going to be a covered disability. Next question is a little more tricky.
So next question is, would it be discriminatory for her employer to fire her because she has been late for work if they do so before she requests an accommodation? So would that be discrimination? She's now been terminated because she's been pretty regularly late for work. She has not requested an accommodation, but she has a disability. So about half of our audience, Matt, thinks that it would not be discrimination for the employer to fire her under these circumstances, and about half think that we need some more information.
I give this one to the nose, Tom. I think we said much earlier in the presentation, that the protections of the Americans with Disabilities Act only apply to known disabilities. There's nothing really in this fact pattern that indicates that the employer is aware that Natalie is a person with a disability. I think that they just know that she's coming in occasionally late for work. So unfortunately, because she got terminated prior to making the reasonable accommodation request, she doesn't have any protections under the law. That doesn't mean the employer still couldn't reconsider and apply, but the question was, would it be discriminatory? And the answer is, in this instance, no.
Yeah, and I think what you said there about the employer's awareness of her disability is the key factor, and I think that might be why some of our audience felt that we need some more information. Because if the employer was aware that she had a disability, even if she hasn't yet requested an accommodation, could there be a circumstance under which that awareness might heighten their obligation to at least offer Natalie the opportunity to request an accommodation before they terminate her?
Yeah, that's a great point. I should have addressed that. But if an employee is starting to slip, making mistakes that they normally wouldn't, you can imagine some factual scenario that would require additional information to really figure out if the employer should have known that Natalie was a person with a disability in this instance.
Yeah. Yeah. I'd want to know if other employees in similar positions as Natalie have been terminated for similar
Yeah.
transgressions, or if not, if they let everyone else slide and everyone is late, from time to time, then that would at least raise some red flags.
Yeah. All right, let's move to the next slide, which has to do with leave of absence as a reasonable accommodation. Comes up more than you would think. A lot of employers don't necessarily fully understand their obligations under state and federal law to provide a leave of absence to people with a disability. Again, it's going to depend on the individual facts and the size of the employer and things like that. But given what we said earlier, that reasonable accommodation is a change or adjustment to your job that allows you to perform the essential functions of your job, it's a little bit of a leap for some employers. Well, why would I have to give this person a leave of absence? That doesn't allow them to perform their job. But when you step back and take the much broader view of the situation, a leave might just be the only thing that would allow someone to come back to perform their job duties. And courts have been very clear that leave of absence is a perfectly valid request for a reasonable accommodation, subject to whatever individual assessment the employer has to do with it. So with that in mind, we've got an example of a leave of absence. I'll read this example, and we're going to ask you 4 separate questions about it in the polling. Steve has alcoholism and has decided to enter a residential treatment program. He has no FMLA, Family Medical Leave Act rights because his company has less than 50 employees. So assume that he doesn't have any right to take leave under this federal law, the FMLA, or state law.
So the first poll question that we have, and this is the last slide that we have poll questions on, is Steve eligible for a reasonable accommodation? So a couple of factors to think about here is Steve a person with a disability? And does he have, even though his employer is not subject to the FMLA, does he have at least the right to ask for an accommodation of a leave of absence? And about 8/10 of our audience, Matt, think that the answer is yes.
Yeah, that's correct. Alcoholism is a recognized disability, and he's certainly eligible to request leave as a reasonable accommodation as a result of that disability because he's seeking treatment.
Thanks. Next question is, can his employer claim that giving him a leave of absence would be too difficult or expensive? So we'll launch the poll question. We're getting at, obviously, when we're talking about difficulty or expense for an employer, we're talking about undue hardship. Can his employer claim undue hardship? About a little more than 2/3 think yes, and about a quarter of our audience thinks that we need some more information on this one.
Yeah, I think both the yes answer and the possibly the need more information answer is correct, but without knowing the size of the employer and the resources available, the employer is likely, assume it's a small employer, then certainly, yeah, they're going to be able to claim that they're not obligated to provide him with a leave of absence. If they have no one to cover that position, for example, if they would have to hire someone new to replace him, and that was going to cost a lot of money, as hiring tends to do, they might be able to claim it. But if we're talking about Amazon, and there are thousands of drivers, and Steve is one of them, then it's very likely that that kind of undue hardship argument is not going to be successful.
Thanks. So they give him a leave of absence. Can they replace him while he's on leave? Let's launch that, see what the audience thinks. This one's split between yes and no. More than half, a little more than half think no, though, Matt.
Employer can replace Steve with the caveat that when Steve is able to return to work at the end of his agreed upon leave period, he's entitled to have a job again at the company. It may not be the same exact position that he had when he left, but yes, an employer can temporarily replace the employee who's out on disability leave, but no, they cannot make that a permanent replacement. I'm guessing that's where some folks got tripped up on this question.
Okay. And the last question, can they terminate him if he is caught drinking while he's at work? See what the audience thinks. And most folks think that yes, they can terminate Steve under those circumstances.
That is correct. This is like as long as this policy of not drinking on the job is uniformly, as long as it's a rule that's in place and it's uniformly enforced among the employees, then absolutely they can terminate Steve for drinking on the job. The fact that he has alcoholism doesn't protect him from the consequences of drinking on the job for that one. So you can go to the next slide. We've got a couple more example slides, and then I'll really quickly point out some resources and make sure to leave us 10 minutes at the end so we can get to people's specific questions or observations. So other accommodations that we've talked about earlier are alluded to earlier, modifications of supervisory process, having excuse me, you might be a person who needs tasks reviewed with you orally by your supervisor rather than having it in writing. You might have a supervisor who would show you what to do or have you take a video of the task that you need to perform rather than just telling you what it is that you need to do. You might need to get more frequent feedback. Some employers only give you a performance evaluation once a year. You might be someone with a memory-related disability and need much more frequent feedback than a once-a-year performance evaluation. And other examples that we sometimes see are having a peer support type of person come with you for a disciplinary or performance review situation that would be able to help you kind of, as a reasonable accommodation, help you understand what you need to do better at your job. Next slide, please. Then the last big category of reasonable accommodations in the workplace is modifications of policies and procedures. We've given quite a few examples of this already. These are sort of very broad, common types of RAs where employers have to modify job duties consistent with business necessity. Keep in mind, most rules are going to be job related. Employers are never going to be required to put up with abusive behaviors that, as long as those are not commonplace in your workplace. But some big picture examples of modifications of policies and procedures is allowing someone to have a service animal with them at their desk. We had that last year with a librarian. Working from home, that was a bigger sticking point for employers pre-pandemic. Dress code modifications and methods of communication, stuff that we talked about earlier, getting a written, oral versus written feedback and things like that. I'm going to tick through the next two slides really quickly because we're running out of time. A few practical tips. Try to be the one to control the flow of information between you and your medical providers. You don't want to just sign a general release that would allow your employer, like Riz said, to go on a fishing expedition with your medical provider. you want to control that information. You may want to get legal advice if you're not sure what to provide and what not to provide. If you do talk about your workplace issues with your colleagues, which you probably shouldn't, you're opening the door for your employer to be able to ask those colleagues, well, what did he say to you about this reasonable accommodation request? You're really opening the door to something that you probably don't want to open the door to. Again, try to disclose requested accommodation before you have any kind of performance issues and get that documentation of whatever you decided with your RA request in writing. Supervisors change all the time, and then people who had an approved accommodation in place for years are starting fresh with a new manager, and nobody's happy in those scenarios. So the last two slides you can take a look at maybe in your own time. It's just a listing of helpful additional resources. We've already alluded to a couple of those during the presentation. And then if all else fails, there's a final slide that shows you where to go to file a complaint with either the state or the federal agency that handles employment discrimination claims. And you don't need a lawyer to file at either of those venues. But if you're to that point, you should probably be seeking legal advice from the Disability Law Center or someone else in your community. I think that's all for my formal part of the presentation, Tom.
Thank you, Matt, and thank you, Riz. And thank you to the audience for participating in those polls. I think that was very helpful to get some feedback. So we have a little under 10 minutes left, so we'd like to open it up to questions. Please feel free to use the Q&A function at the bottom of your screen, or raise your hand and we can unmute you to state your question. We do have a couple that have been typed into the Q&A in the last couple of minutes. So let me take a look at these. The first one: can part of a structured or flexible work schedule reasonable accommodation be based on the fact that disability needs a certain amount of treatment? This would include actual appointments and the work that is required responsive to them. For example, practicing or working on the coping skills recommended by a therapist. So I think, and Matt and Riz, feel free to jump in. I think that the crux of this question is, would it potentially be a reasonable accommodation to request a flexible schedule if you have a disability-related need to periodically receive treatment or go to appointments, things like that? And the answer is definitely a yes, qualified, of course, by the fact that we would need to, on a case-by-case basis, look at the essential functions of that person's job to determine whether or not an accommodation of a flexible schedule would be reasonable. So we'd want to know, what is the person's schedule? What are the functions that they need to be performing during certain periods of the day? And which of those functions or what time periods would be affected by their need to receive some flexibility in terms of their being at their job. So as you can imagine, there might be jobs where it could be difficult for the employer to give flexibility to a person. For instance, if they're the only person performing a very important function that needs to be performed during specific time periods, then that might be more of an undue hardship. But I think for most jobs, some flexibility would most likely be reasonable. So another question regarding the obligation to change a supervisor. This was something that Matt just spoke on recently. Suppose that the employee suffers from severe anxiety and depression, and the supervisor's behavior, bullying, is exacerbating his symptoms. Can a change in the supervisor then be considered a reasonable accommodation? Matt, you have some thoughts on that one?
I do. I think the overarching theme is going to be that it's extremely rare. I've never seen it, a supervisory change as a result of reasonable accommodation request, but we can't say categorically yes or no whether that could happen. It's all going to be based on the individualized factors that we talked about before. And if you get into like a company that's really, really big, and it wouldn't really have much of an impact on operations to change a supervisor for a very specific need, disability related need, could theoretically be possible. But if you're talking about bullying and other things like that, then you're going to have HR involved because it sounds like there's some other potential other things are going on beyond a request for reasonable accommodation.
Yeah, I agree with that. And for me, what that triggers is something that we didn't touch on, just a little bit beyond the scope of today's presentation, but disability-based harassment in the workplace is also something that is illegal. So if there is, if there's evidence that this supervisor is targeting this particular person because of their disability, then, similar to sexual harassment in the workplace, that would be something that that the employer would certainly need to address.
Can I jump in on just want to say
Sure.
one
Yeah,
thing on
thanks, Chris.
that? Is that the one thing we didn't talk about is that there's really no law that says that the employer from being that your supervisor's a jerk. So if they're treating all the employees a certain way, it's going to be hard to get I mean, I've never seen the request for reasonable accommodation change supervisors actually happen in the real world. But one thing to keep in mind is just because your supervisor is a jerk who doesn't treat everybody nicely, is not really a basis for discrimination, even though you may have a disability. They're not treating you like that because of your disability. They treat everybody. And
Right.
that, when we see cases like that, there's no standing there for legal action.
Yeah. Yeah, I agree, Riz. So you really have to look at the particular circumstances and is the person, is there evidence that the person might be being singled out in some way? We have a question about PFML, the state family medical leave. How similar are protections to disability protections, or taking leave for the needs of a family member's disability, or is it different? It's actually an interesting question. Gets to some of the limits of reasonable accommodation, but some of the protections that are provided under the various leave acts, state and federal. So under FMLA or under the state equivalent, a person can take a leave based on their need to assist a family member who might have a disability or a medical condition. Under the ADA, under discrimination law, reasonable accommodation, accommodations are only for the individual who is employed. So there aren't that many circumstances where, as an accommodation, an employee would be able to sort of take time off to care for a family member, but they may be able to do that under the family leave laws, the FMLA and the state equivalent. And last question, and we're just about at the end here, which is good. In terms of our timing, with or without reasonable accommodation is confusing phrasing, seeming to be possibly interpreted as whether or not the person receives the accommodation, but it seems counterintuitive. Yeah, the phrasing on that is not ideal, but and I alluded to this in the Q&A earlier in the presentation. The idea here is that the employer does need to at least consider reasonable accommodation in determining whether or not the person is qualified for the job, which of course, as I think it was Matt who alluded to earlier, really puts the impetus on the employee to make sure that if they need an accommodation, that they ask for one in order to give them the ability to perform the essential functions of the job. So that's it for the questions, and it is exactly 2:30, so we're going to wrap it up. Thank you so much to Matt and Riz for a great presentation. Thank you to our interpreters. Thanks Amanda and Caitlin for running this behind the scenes. And thank you to our audience for participating in the polls. We really appreciate your being with us today. Take care.